Enzorecto, kalaban ang katiwalian at kasinungalingan, kakampi sa katotohanan at kabutihan.
Good afternoon. As early as the second half of the 14th century, the concept of impeachment emerged in England as a means of holding high officials to account for misconduct. In 1787, it was adopted into the United States Constitution, granting the House of Representatives power to impeach and the Senate the power to try impeachments. The United States later introduced impeachment to the Philippines during the Commonwealth period through the 1935 Constitution. This framework adopted the U.S. model, specifying the grounds for removing the President, Vice President, Justices of the Supreme Court, and the Auditor General. It granted the House the power to impeach by a two-thirds vote and the Senate the power to convict by a three-fourths vote. While the 1935 Constitution laid the foundation, the 1973 and the 1987 Constitutions refined both the process and the grounds for impeachment. The 1973 Constitution, under a parliamentary system, gave the National Assembly the exclusive power to initiate, try, and decide all cases of impeachment against the President, Supreme Court justices, and the members of the constitutional commissions for culpable violation of the Constitution, treason, bribery, other high crimes, or graft and corruption. The 1987 Constitution, which restored the bicameral Congress, preserved impeachment under Article 11, Section 2 and 3. It specifies the impeachable officials, the exclusive power of the House to initiate, and the sole authority of the Senate to try impeachment cases. It likewise grants both chambers the constitutional right to promulgate its own rules to govern impeachment proceedings. For 90 years, this system stood. But on July 25, 2025, the Supreme Court of the Philippines rendered its decision in Duterte versus House of Representatives, GR number 278353, and changed the course of our constitutional practice. Mr. Speaker, I will not belabor the chorus of voices calling the decision gravely erroneous in fact and in law. Rather, I will focus on its adverse effects and ominous consequences to our constitutional duty to demand accountability from high officials. The decision not only declared void ab initio the plenary-approved articles of impeachment against the Vice President Sara Duterte transmitted to the Senate on February 5, 2025, it also ruled that she was denied due process under the Bill of Rights. The court held that due process applies at all stages of impeachment and imposed 7 new due process requirements on the House. Per Supreme Court decision in Duterte versus House of Representatives et al., GR 278353, July 5, 2025, due process requirements in impeachment proceedings are as follows. Number 1, the articles of impeachment or resolution must include evidence when shared with House members, especially those who are considering its endorsement. Number 2, evidence should be sufficient to prove the charges in the articles of impeachment. Number 3, the articles of impeachment and the supporting evidence should be available to all members of the House of Representatives, not only those who are being considered to endorse. Number 4, the respondent in the impeachment complaint should have been given a chance to be heard on the articles of impeachment and the supporting evidence to prove the charges prior to its transmittal to the Senate, despite the number of endorsements from House members. Number 5, the House of Representatives must be given a reasonable time to reach their independent decision of whether they can endorse an impeachment complaint. The court, however, has the power to review whether this period is sufficient, but petitioner who invokes on the court's power to review should prove that officials failed to perform their duties properly. Number 6, the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during their current term, the current term of the impeachable officer. For the President, the Vice President, these acts must be sufficiently grave, amounting to the crimes described in Article 11, Section 2, a betrayal of public trust given by majority of the electorate. For the other impeachable officers, the acts must be sufficiently grave that they undermine and underweight the respect of their constitutional independence and autonomy. Number 7, to ensure that respondent in the impeachment complaint is heard under the requirements of due process in the procedure under Article 11, Section 3 to Paragraph 4, the House of Representatives is required to, letter A, provide a copy of the articles of impeachment and its accompanying evidence to the respondent to give him or her an opportunity to respond within a reasonable period to be determined by the House rules. The Constitution only requires an opportunity to be heard. It is up to the respondent to waive this fundamental right and opt to present his or her evidence at the Senate trial. And letter B, make the articles of impeachment with its accompanying evidence and the comment of the respondent available to all members of the House of Representatives. It is the House, not 1/3 of the House, that has the sole prerogative to initiate impeachment complaints. Thus, there must be some modicum of deliberation so that each member representing their constituents can be heard and thus convince others of the position. That transmittal, however, will only take place upon the qualified vote of 1/3 of the House. That was the decision of the Supreme Court on the 7 requirements, Mr. Speaker. These requirements are nowhere found in the Constitution. They amount to a direct intrusion into the House's exclusive constitutional authority to adopt its own impeachment rules. Many call this judicial overreach. I say it is judicial amendment of the Constitution. The right of the House to promulgate its own rules is clearly and plainly stated in our fundamental law. It is not for the Supreme Court to write rules and for the House to follow. The judiciary has the vital role of interpreting laws, including the Constitution. But that role does not extend to amending it. The power to interpret does not include the power to rewrite, Mr. Speaker. Yet, the decision effectively rewrote our impeachment rules, imposing requirements that are impractical, if not impossible, to fulfill. First, it mandates the House furnish the respondent with the articles of impeachment and supporting evidence to allow them to respond before transmittal to the Senate. But the Constitution requires referral to the complaint to the proper committee within 3 session days, an impossible time frame for debate, notification, comment, and hearing. Failure to meet this deadline renders such proceedings unconstitutional. Second, it requires that articles supporting evidence and the respondent's comment be made available to all members. This opens the process to sabotage. A single member could invalidate proceedings simply by claiming they were not furnished or did not understand the documents. Such a scenario could not have been intended by the framers. Third, it holds that mere filing of an impeachment complaint, acted upon or not, constitutes initiation and triggers the 1-year bar. This dangerous precedent allows a crony to file a frivolous complaint the moment the bar expires, effectively shielding an impeachable official from real accountability year after year. The cumulative effect of this pronouncement is to ensure that impeachment against the Vice President and future impeachments against any official will not survive. One must ask, did the members of the Supreme Court wittingly or unwittingly shield themselves from impeachment? Let us remember, the last impeachment case before the Vice Presidents involved a sitting Supreme Court justice. Mr. Speaker, the Venerable Senator Claro M. Recto, principal drafter of the 1935 Constitution, must be turning in his grave. But not all is lost. The people's right to demand accountability from their highest officials must remain our guiding principle. This decision, while formidable, is not an insurmountable barrier. We must explore every avenue, navigate every obstacle, and take even the narrowest path to fulfill our constitutional duty. This House shall not bow in silence. The House has already filed its motion for reconsideration. The Honorable Supreme Court still has the opportunity to rectify its ruling, to issue a decision aligned with the facts, the letter and spirit of the Constitution, the principle of separation of powers, checks and balances, establish precedent, and most importantly, the people's right to demand accountability.
Bunyog, bunyog, halikan na kasama ka. Bunyog, kapag buklod ay may pag-asa. Luzon, Visayas, Mindanao, isa ang pananaw. Sa bagong Pilipinas ang bunyog isisigaw. Bunyog.